Breaking: Birthright citizenship, once guaranteed to nearly every child born in America, has effectively ended in most of the United States. For the first time in over 150 years, a U.S. president has successfully restricted who can become a citizen at birth. The consequences are massive, reaching millions of immigrant families and raising questions about the nation's identity, laws, and future. This is Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. When Donald Trump returned to the White House in January 2025, he immediately revived one of his most controversial promises: ending automatic citizenship for children born to non-citizen parents. On his very first day, he signed Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. This order changed the way the 14th Amendment is interpreted, declaring that only children with at least one U.S. citizen or lawful permanent resident parent would automatically receive citizenship at birth. The order took effect just 30 days later, on February 19, 2025, and within months, its impact spread across the nation. What changed? For over 150 years, the 14th Amendment had been understood to grant citizenship to anyone born on U.S. soil, regardless of their parents' immigration status. Trump's executive order redefined this, excluding children of undocumented immigrants, temporary visa holders such as students and tourists, and even some long-term residents without green cards. Federal agencies were instructed to stop issuing passports, social security numbers, and other citizenship documents to children who did not meet the new criteria. While states still issue birth certificates, federal agencies no longer treat those certificates alone as proof of citizenship. Instead, proof of a parent's U.S. citizenship or green card is now required in affected states. Supreme Court ruling. Almost immediately, lawsuits were filed. Civil rights groups, immigrant families, and more than 20 states argued that the order violated the Constitution. Federal judges issued injunctions blocking the policy in some states, creating confusion nationwide. But on June 27, 2025, the Supreme Court issued a pivotal ruling. The court did not rule directly on whether the executive order is constitutional. Instead, it restricted lower courts' ability to issue nationwide injunctions. That procedural shift allowed Trump's order to take effect in most of the country, while still being blocked in a handful of states like Colorado, where local lawsuits continue. Trump called the ruling a monumental victory for the Constitution and the rule of law. Who this affects? The new rules hit several groups hardest: children of undocumented immigrants, children of parents in the U.S. on temporary visas, students, tourists, or short-term workers, families where parents have lived in the U.S. for years but never obtained a green card. In practice, this means that a baby born in New York to two international students is no longer a U.S. citizen at birth. A baby born in Texas to undocumented parents is also excluded. Only children with at least one U.S. citizen or green card holding parents still qualify automatically. Enforcement and confusion. Hospitals continue to issue standard birth certificates, but families quickly discover that a state-issued certificate is not enough for a passport or social security number. Parents are now required to show immigration documentation proving citizenship or lawful permanent residence before the federal government will recognize the child as a citizen. This change has created widespread confusion and fear. Families worry about their children's ability to access healthcare, education, and basic benefits. Some immigration lawyers warn of the risk of statelessness, where a child is denied citizenship in both the U.S. and their parents' home country. Real-life examples. Consider a couple on H-1B and H for visas who have lived legally in the U.S. for years, waiting for their green cards. Their baby, born in March 2025 in California, does not automatically receive U.S. citizenship under the new rules. Or think of a refugee family still in the asylum process. Their U.S.-born child may be left without clear status if neither parent has permanent residency. These are not hypothetical scenarios. They are playing out in hospitals, schools, and immigration offices right now. Risks and consequences. The risks extend far beyond paperwork. Children denied citizenship may struggle to enroll in school, qualify for medical coverage, or travel outside the country. Immigrant families fear long-term consequences. Children growing up without legal status, facing barriers to jobs, education, and stability. The policy also complicates mixed-status households, where some children are citizens while others are not, creating painful divisions within families. Possible benefits. The Trump administration argues that these changes protect the integrity of American citizenship. Supporters claim the policy deters birth tourism and reduces incentives for illegal immigration. They also argue it aligns the U.S. with most other countries, including Europe and Asia, where at least one parent must be a citizen or permanent resident for a child to qualify. Family petitions under new scrutiny. Alongside birthright citizenship changes, USCIS has introduced tighter scrutiny of family-based immigration. I-130 petitions, the main form for sponsoring relatives, are now subject to enhanced verification, interviews, and closer examination of financial information. Officials say this is to prevent fraud and ensure stronger vetting, but applicants are already reporting longer delays and more evidence requests. Together, these measures show a broader shift in U.S. immigration enforcement in 2025. Tips and warnings. If you are a parent or expecting a child, be aware of the following. Birth certificates alone may not prove citizenship for federal purposes. Keep documentation of your lawful status ready if you plan to apply for your child's passport or social security number. Families on temporary visas should consult with an immigration attorney to explore options for protecting their children's status. The end of birthright citizenship marks one of the most dramatic changes to U.S. immigration law in generations. It creates uncertainty for millions of families, redefines the 14th Amendment's legacy, and sets up future Supreme Court battles. For immigrants, the message is clear: documentation matters more than ever. If you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching Immiscope. See you in the next video.